This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we talk about why an insurer must consider new facts even after a court rules it has no duty to defend, and why the duty of good faith and fair dealing continues even after the court finds no duty to defend, and new facts require a new decision by an insurer. Nautilus Insurance Company was entitled to rely on a trial court Judge Dorsey's summary judgment ruling in a previously filed separate declaratory judgment action in which Judge Dorsey determined Nautilus did not have a duty to defend at that time. Because Nautilus was told it did not have a duty to defend Plaintiff Robert Wood, it was not liable for bad faith failure to settle during the September 2016 mediation, 3 days after the summary judgment ruling. However, in Robert Wood et al. Versus Nautilus Insurance Company, the United States Court of Appeal for the Ninth Circuit on May 8, 2025, resolved the dispute over bad faith conduct with a reliance on later developed facts. The Ninth Circuit concluded that the district court did not commit clear error in determining Nautilus was not liable for bad faith failure to settle because Nautilus did not have a duty to attempt to settle until there was a duty to defend, which was not triggered until after the first retender of the claim, or the fourth tender. To allege a claim for bad faith, a party must plead facts sufficient to demonstrate that the insurer had no reasonable basis for disputing coverage and that the insurer knew or recklessly disregarded the fact that there was no reasonable basis for disputing coverage. Finding that arguments not raised clearly and distinctly in an opening brief are forfeited. Wood forfeited his claim for emotional distress damage by not clearly and distinctly asserting the claim in his opening brief and merely stating, quote, because the district court denied Wood's failure to settle claim, it also denied his claim for emotional distress damages, close quote. A plaintiff must establish a bad faith claim to be entitled to emotional distress damages. Given Nautilus was not liable for bad faith failure to settle, Wood had to tie his emotional distress damages to the denial of the third of fourth retenders, the only acts found to be in bad faith. Wood failed to do so, and as such, the district court properly denied his claim for emotional distress damages. The district court did not commit clear error in finding that Nautilus is also not liable for bad faith failure to investigate the pre-mediation evaluation report. The Ninth Circuit concluded that the September 23, 2016 pre-mediation report did not trigger Nautilus's duty to defend. It merely provided additional evidence of a potential duty to defend. However, Judge Dorsey's order in the first coverage action 3 days before the mediation made clear Nautilus did not have a duty to defend. It was reasonable, therefore, for Nautilus to rely on the court order concluding it did not have that duty. The district court properly concluded that the punitive damages awarded in the underlying suit, the Switzer action, were not recoverable against Nautilus because such indemnification is prohibited by Nevada public policy. Punitive damages must be paid by the evil person against whom they were awarded. The unjust enrichment claim against Nautilus hinged on whether equity required the policyholder to pay. The Nevada Supreme Court has determined that when a court determines that the insurer never had a duty to defend and the insurer clearly and expressly reserved its right to seek reimbursement, it is equitable to require the policyholder to pay. It was ultimately determined that Nautilus had a duty to defend Wood in the Switzer action, and therefore Nautilus cannot be said to have performed in excess of what was bargained for between Wood and Nautilus. Subsequently, the district court did not err in determining Nautilus was not entitled to reimbursement of its defense costs before July 28, 2017. The district court found that Nautilus's denial of the duty to defend became unreasonable only after Wood's third retender, when it was revealed that an email falsely stated that Switzer was banned from selling certain implants in California. The district court concluded that, quote, while it was reasonable for Nautilus to rely on Judge Dorsey's rulings to some extent, close quote, once the falsity of the email was known, Nautilus, quote, recklessly disregarded, close quote, the fact that there was no reasonable basis for disputing coverage and therefore acted in bad faith. The district court concluded Nautilus acted in bad faith, therefore, in denying the fourth retender, and that account of the evidence is plausible in light of the entire record, and therefore the district court's determination was affirmed. In my opinion, after an insurance company receives a trial court judgment that it has no duty to defend, it can refuse to defend or participate in a mediation. However, the duty of good faith does not go away, and the insurer must consider in good faith new facts that create a duty to defend. Nautilus was not required to pay punitive damages against its insured, nor was it entitled to a refund of the funds it spent to defend the insured, because of the fourth tender and its evidence created a duty to defend. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll also gain access to the more than 5,050 blog postings. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And please, if you subscribe to the videos, which are also free, please consider clicking on the like button on YouTube or the thumbs up button on Rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.